Hello, everybody. My name is Maria Cahill. I'm a professor of law at University College Cork in Ireland. So I'm a little bit of an interloper into these conversations in these forums, but I have had an interest for a number of years now in social ontology and the ways in which law can learn from the advances and the insights that are coming from this discipline in order to respond more sensitively to the needs of groups. So my research and this paper is focusing on groups and the ways in which they are protected or not protected through the mechanism of freedom of association. I'm going to share my slide now with you. So the first thing is to just put a little bit of context on this. Obviously, other rights that are protected by law, such as freedom of expression, freedom of religion, freedom of conscience, privacy, property rights, and so on, some of them necessarily will involve other people, but the place of other people in the articulation of those rights and in the way in which courts deal with those rights is not front and center. It's not as visible as it is in freedom of association. So freedom of association ends up being slightly different from other rights because it's protecting the individual, but it's protecting the individual in their sociality rather than in their individuality. So law and judges and courts have found it slightly tricky. There's an inherent tension there, or a paradox, as some of the literature says, that we haven't fully got to grips with yet. And as a result of that, maybe what we could call law's lack of comfort with that paradox, freedom of association has become slightly a forgotten freedom, or a right that's sort of left by the wayside, that gets a lot less attention than other rights that, and you might already be aware of that, obviously. At the same time, Cahill said a long time ago that none of the rights deserve more attention than this one, but it is the one that has the most potential for creating the conditions for a good democracy. And more recently, Amy Gutman said that the value of it has not received, the right has not received as much attention as it deserves because relative to the value that it promises. And the promise, of course, is connected with freedom of association's capacity to honor pluralism in society, and pluralism not only understood in the sense of there being different races or religions or different cultures in society, but also there being groups of people who act towards the pursuit of particular aims which are for the good of society as a whole. Okay, so on the ground and in the courtrooms, freedom of association has had this sort of perplexed and slightly difficult time. And then in scholarship, there are some theories of freedom of association, but those theories tend to fall into one of two categories. Those theories that focus on a single jurisdiction and try to explain and put a frame on the way in which courts in one jurisdiction handle freedom of association. And they're fine and good as far as they go, but they don't take into account then that different jurisdictions deal with freedom of association in radically different ways, as we'll see in this presentation. The other kinds of theories that exist in relation to freedom of association are quite normative theories, hyper-normative theories that think about its potential, that think about its possibility for increasing increasing the quality of our democracy, or increasing the quality of our pluralism, or other kinds of good things that can happen. Sorry, now that I'm blanking. So there's one theory that says that freedom of association properly defended and vindicated can increase the moral character of our nation through helping individuals, that it can increase human happiness, that it can improve the quality of our democracy, guard against constitutional decay, and then fulfill our commitments to diversity and pluralism. And those theories are also very good, but they're not connected, as I say, to what's going on the ground. So there is a little gap here, which I'm trying to fill in two ways. One, that I'm trying to connect the normativity of the theory to what's happening on the ground, and in the second way that I'm trying to expand our horizons beyond a single jurisdiction. So before moving on to the next slide, I just wanted to deal with a couple of definitions. So when I'm speaking about associations, I mean, as I have implied already, groups of individuals who've come together in an organized way in pursuit of particular aims. So paradigmatically for this presentation and for my work, there are things like sporting organizations, youth organizations, charitable organizations, cultural organizations maybe. I tend not to think of trade unions or religious organizations as paradigmatic examples, only because those areas, labor law and freedom of religion, are treated in slightly different ways and have a whole body of case law built up around them. So just to focus on freedom of association, I'm trying to pick out the types of associations that aren't already hyper-regulated and aren't already, and deal with freedom of association in simple terms. So then my associations are different from crowds, which are unstructured groups, and different from minority groups, which are aggregates of individuals who have a particular characteristic in common, like women, people from a particular race, people from a particular ethnicity, persons with disabilities, or so on. So those are not, sometimes in law, we call those minority groups. Those aren't my kind of groups. My kind of groups are people who are organized in the pursuit of particular aims. Then the right of freedom of association, courts have determined to encompass three elements. First is what's called freedom to associate, which means the right to create or to join an association. Second, there is freedom to disassociate, which means the right to leave or to refuse to join an association. So a prevention of any kind of regulation that would require compulsory membership, for example, of a trade union, although again, that's not my paradigm example. So first element, freedom to associate, second element, freedom to disassociate, and third element, freedom of association, meaning the organizational autonomy of the group itself. And that element is most interesting for me, because that's the right of the group to decide its own conditions, to make its own rules. And that's the one that, I guess, in a way creates the most conflict, because disputes can arise then when the values of an association don't line up with the values of the jurisdiction in general. Maybe the association's values don't line up with the principle of non-discrimination. For example, if they have an exclusionary membership policy and the rules of non-discrimination require that all kinds of persons must be capable of joining the particular association. So disputes can arise there. One term that the literature uses quite a lot is the idea of congruence, which is the idea that regulators will sometimes impose on an association a duty to conform its own membership policies and internal regulation to values such as non-discrimination, or to other kinds of values of good governance that are established legally. So that requirement that the internal life of the association should mirror the life of the democratic state. Okay, so with all of that as an introduction, I'm going to dig into what I've been finding. This is from now on going to be the results of my comparative study. So here you see the list of jurisdictions that I have been dealing with the help of some research assistants. And they are mostly nation states. And at the end, you have the Court of Justice of the European Union and the European Court of Human Rights, so covering 27 and 47 jurisdictions respectively. And it's quite a mixed bunch, with Brazil, Russia, Poland, South Africa, all included in there. I'm not going to refer to every jurisdiction in the presentation that follows, because I have tried to group the ways in which courts respond to freedom of association. So what I'm essentially doing here is trying to identify, when the courts are dealing with freedom of association, what is it that they think they are defending? So obviously they'd have to defend the right, but what is it that they think they're doing in defending that right? What's the rationale behind it? And I have found that there are three kinds of rationales. One, a state-centered rationale, which protects freedom of association, but for the sake of the state. Secondly, an individual-centered rationale, which protects freedom of association, but for the sake of the individual. And third, then the group-centered rationale, which protects freedom of association for the sake of the group itself. And so, in answer to the question, why are associations valuable to law? These are the reasons, either for the sake of the state, for the sake of the individual, for the sake of the group. And possibly we're happy with all three. I haven't decided yet what I think. Possibly it's right that all three rationales should be interwoven. Possibly we lose something if we're only focusing on a state-centered rationale or an individual-centered rationale. Possibly we should be moving more in the direction of a group-centered rationale. All that to be determined. At the moment, I'm just trying to lay out what I'm finding through the comparative research, and hopefully it will be interesting. So moving on to, I'm going to have a couple of slides here in relation to state-centered rationales, because there are three different kinds of state-centered rationales. The first one is a state-centered rationale, which is given by the European Court of Human Rights. And so this is just one extract from one judgment. There are many more I could have taken. But here's one paragraph which explains that the court thinks that even associations that are non-political, right? It's starting this passage by referring to the role of political parties, which it considers to be a certain kind of association. And then it goes on to say that associations formed for non-political purposes, like protecting cultural and spiritual heritage, pursuing socioeconomic aims, proclaiming or teaching religion, seeking an ethnic identity, and so on. All of these are also important to the proper functioning of democracy. So it really thinks of associations as ordered towards the functioning of democracy. And later in the same paragraph, the participation of citizens in the democratic process is to a large extent achieved through belonging to associations. So here it seems that associations are a funnel for democratic participation. I'm not sure that that rings true to our experience. When we join a cultural or spiritual association, are we thinking that we're doing that in order to properly contribute to democracy, or a sporting organization or so on? I'm not sure, but anyway, this is the lens through which the court looks at associations and sees their value. The European Court of Human Rights, that is. Okay, so moving on, the German Federal Constitutional Court has the same kind of state-centered approach, but here the rationale is, I guess, within that umbrella of state-centered rationales, it's slightly different. So Article 9.1 of the Grundgesetz, Article 9.1 of the Constitution, the basic law of Germany, it's saying guarantees this principle of free social formation and foundation of groups. So the state shouldn't systematically form and organize groups according to the value standards set by the ruling group. So that's sort of a stance against congruence, that it shouldn't be the case that the state can impose on social groups the kinds of values that it has itself, because, as it goes on to say, and I haven't underlined here, that's a characteristic of totalitarian states. So instead, the German Federal Constitutional Court wants to see associations being formed sort of for the protection of the state against totalitarian tendencies it might have. So it's sort of counterweight against totalitarianism. So again, it is, I guess, for the sake of democracy, but the framing is slightly different in that associations are the safeguard. The German Federal Constitutional Court seems to think against a tendency towards totalitarianism. The third example that I have of a state-centered rationale is coming from the Spanish Constitutional Tribunal. I could actually also have chosen some quotes from the Polish Constitutional Tribunal. Both jurisdictions are committed to the principle of pluralism as a foundational principle within the constitutional system. So it seems to me that for these jurisdictions, pluralism is one of the hallmarks of the democratic tradition that they want to safeguard in their country. And so that means then that you need to have mobility and self-determination and competition of social subjects, that you need to have freedom of association. Now, it's arguable, I guess, that in protecting pluralism, these nations and these courts are actually trying to protect the groups for their own sake. So possibly I have miscategorized this, and it should fall under group-centered rationales. But I think when we get to the group-centered rationale, it might be possible to see why I've chosen to keep it in this place, why I've chosen to keep Poland and Spain here. It just seems to me that here, these two jurisdictions are seeking to protect freedom of association, again, for the sake of a characteristic of the state rather than for the sake of the group itself. But I see that it is debatable. Moving now to individual-centered rationales. So the quote that I have included here is a quote from the Canadian Supreme Court. I could also have included under individual-centered rationales some quotes from the US Supreme Court, and some quotes surrounding the interpretation of freedom of association in France. It is, by the way, also true that some courts, including those two that I just mentioned, or well, maybe mostly the US Supreme Court, actually, I would say more than the French courts, that they protect freedom of association for the sake of freedom of expression, that they consider freedom of association almost to be a subset of freedom of expression, freedom of speech. So that's another dynamic in all of this that I'm not getting into today, but it's there. So just as an example, here I have on the slide one court, the Canadian Supreme Court, that really does think of individual-centered rationales, not for the sake of any other right that the individual has, but just for the sake of the individual in her own pursuit of her social aims. So the quote here nicely reads, historically, those most easily ignored and disempowered as individuals have staked so much on freedom of association precisely because associationism was the means by which they could gain a voice in society. So this then is the fundamental purpose of section 2D of the Charter, that is to protect the individual from state-enforced isolation in the pursuit of his or her aims. The idea here is that when people are in minorities, when their rights are not being given priority in society, when they don't have a good share of the political power, they very much need to be able to join together in order to protect themselves and in order to be able to gain a voice in society. So this is a justification of freedom of association that focuses on the individual and the need to protect the individual, especially when that individual forms part of a minority group. And here, obviously, we have an interplay between groups as understood in associations the way I do, and minority groups, and those two obviously do play. There is a significant interplay there that also could be researched. Now, the final court that we're looking at is the one that I have found to be the most interesting so far in my research, and that is the South African Constitutional Court. And it really does seek to protect the group for the sake of the group, and really not to think very much beyond that. So there is a strong sense in the case law, and also not just kind of theoretically, but also in the application of this idea and of this right in concrete terms, in particular situations. There is a strong sense that we need to uphold the group, even if we don't like what the group does, even if we don't like the values that it holds, even if we don't like the decisions that it makes as regards who it's going to accept or not accept into its ranks, that we really need to protect the group, because strong protection of the group allows for the existence of that group, but also allows for the existence of groups that are going to pursue other aims. And so it's sort of a free market of groups that they're trying to establish, that you make the barriers to entry, or the barriers to creation of groups very low, so that you'll have a flourishing of associational life, and then those associations will sort of correct each other in the free market of associations. So here, the special quote in the two lines just at the end is that the protection of this right, freedom of association, is about giving associations, whatever their size, room to achieve the objectives for which they exist. So that really means protecting the group for the sake of whatever the group thinks is important, whatever the group has decided it wants to exist for the sake of. So it's just a different approach, and that's, I guess, it's possible to see now, having just toured those few jurisdictions, that there really are diverging approaches to freedom of association, even if everybody's theoretically protecting the same thing. And so it's worth knowing about this. It's worth being able to compare the different jurisdictions. And when we do that, it seems to me that the majority of jurisdictions are protecting associations for things other than themselves, either for the sake of the state or for the sake of the individuals. It's only really South Africa, and obviously I've only studied 13 jurisdictions so far, but South Africa is the only jurisdiction I've found that seems to protect associations for the sake of associations, and therefore to really value organizational autonomy and the decisions that groups are making. So if that's true, then possibly I might say that law has a lack of sensitivity here to the importance of groups, and maybe needs to be more aware of things like group dynamics and collective intentionality. That law possibly needs to have a little bit more respect for the internal workings of associations, and then maybe it needs to recognize in a more fulsome way the value of associations for their own sake. And that's not to deny that they have also collateral benefits for the state and for individuals. But I think if we only value associations for the sake of the things that they provide us as sort of external goods, then possibly we're missing something important. And I haven't really put my finger on what that might be yet. But that's all part of what I want to explore, and part of the reason why I want to be in conversation with people like you while I do that exploring. So thank you very much for listening to my presentation, and I hope that you found it interesting, and please do reach out and get in contact if there's any insights that it raises in your mind, or any questions that it raises in your mind. Thank you very much.